I represent individuals like you against debt collectors, against banks, against other insurance companies, all kinds of things. And I do that, and I don't have to charge my clients ever. It's free. There are consumer statutes that protect you. Now, what we're going to talk about today is bankruptcy. But before we talk about bankruptcy, I want to talk to you a little bit about the consumer rights that protect you right now. Those consumer rights protect you now, they protect you during bankruptcy, and they would protect you after bankruptcy. Now, nonetheless, you have these rights, and sometimes the best option, simply is bankruptcy. And we'll talk about that and why that is. And so I'm going to talk about your rights, and then I'm going to pass it off to Margaret, who will then talk about bankruptcy and that process and procedure. And then we'll go ahead and handle any questions that you may have as well, okay? So, to get us started, let's talk about why you probably are attending right now. Because somebody is probably contacting you saying they want to get paid on a debt. In fact, most of the time, there's at least 3 debts per household that are in default. And that's a lot, because even if you can handle paying off one of those debts, you've still got 2 more wolves at the door that are looking to get paid. So, what can you do with that? Well, what I have tried to do for consumers for many years, I've been an attorney for 23 years, and I have tried to negotiate that debt. Hey, maybe we can negotiate the debt that's $20,000 down to, say, $1,000 or $2,000, right? Sometimes that works, but that's very dependent, right? Because you have to have the extra money, and there has to not be overwhelming debt. So, for example, if there's $12,000 that's owed, and there's 3 different creditors, but only one of the creditors is willing to work with you, well, that means that you're going to get sued. And getting sued, what that means is that somebody files documents in court in order to obtain a judgment. Now, why is that significant? Because prior to obtaining a judgment, all that happens is you receive letters, you receive texts, you receive phone calls. Usually that happens for about 3 months, and then that stops. And then all of a sudden, another debt collector will contact you, and you'll start receiving letters, and you'll start receiving phone calls, and you'll start receiving that, and then it'll stop. But ultimately, what can happen is it could end up with an attorney. And that attorney normally contacts you and will threaten, hey, we're a law firm, and we're going to sue you if you don't try and work with us. They do what's called, I say, a 3-step drop, right? So what they do is they send you a letter saying, we have the debt. They send you another letter saying, you better work with us. And then they send you a 3rd letter saying, we're going to sue you. And then they do. Now, what does that mean? That just means that somebody will either hand to you or somebody in your household a summons and a complaint. Now, a summons and a complaint will tell you that you have 21 days to answer, to respond to that complaint. The complaints are normally short, 4 paragraphs. You took out an account, a credit card, you used the credit card, you didn't pay the whole thing off, and this is how much you owe. It's a contract case. And they usually use the last billing statement against you in order to prove all those things. Can you fight it? It's very difficult. I've tried fighting these cases many, many years, but the fact is it's very difficult to fight. The best way to go about many of those cases is to try and reasonably resolve them. But again, sometimes they're not willing to work with you, and if they're not, there's not much of a defense in court. So then what happens? Well, ultimately, they can obtain what's called a judgment. A judgment is a piece of paper signed by a judge that says somebody owes somebody money. And why that's significant is because with that piece of paper signed by the judge, they can really cause ripples and problems in your life. Because once they have that judgment, they can start trying to garnish your wages. That means take money from your paycheck. They can also take money from your bank accounts. Okay? And that's very problematic. I'm sorry, I'm getting a little echo. But that's very problematic because it'll happen at the worst time. It'll happen right before you're going to pay the mortgage, right? And so those things are then out of your control. Again, this is just what may have already been happening to get you here today, right? Let's talk a little bit about what rights protect you. Whether you have a judgment against you or not, whether you have debt collectors that are contacting you right now or not, perhaps you're just anticipating this may be what's going to happen. And I guarantee that ultimately when debts go unpaid for 3 months, debt collection and ultimately litigation is exactly what happens. You can anticipate that eventually that is what was going to happen. Just as the economy is very tight for all of us consumers, it's very tight for businesses as well. Debt collectors aren't getting paid, and that means that they're harassing even more so. So, ultimately, what is the fix? Well, that's why you're here today. The fix for me, as a consumer protection attorney for 23 years, has been don't file bankruptcy, let me sue them for you. You don't have to pay me, and then that way it'll fix this problem. But the issue that I run into very often is that the problem is just so much bigger than that. It's not about one debt. And so instead of an either or, what I've come to believe is that what I do actually works in tandem and works perfectly with what my colleague Margaret does, which is bankruptcy. Bankruptcy just levels the playing field, clears everything out. And then when you're getting contacted or harassed by 1, 2, 3, 4, it's much easier for me to focus on those 1, 2, and 3 and take those out for you and sue them on your behalf. Again, it doesn't cost you anything, and you receive damages on top of that, which a lot of times pays for the bankruptcy to begin with, if not more. So again, first off, I just want to applaud you for having, taking the bull by the horns and saying, hey, I want to figure out what my options are. That is what is going to get you through the woods, okay? That is a positive thing for you. And what I want you to remember is filing bankruptcy, right, is just another arrow in your quiver. It's just another tactic. Everybody, including the President of the United States, has done it at every level of business. It is something that's there for you. What I call it is triage. Triage is not surgery. Triage is not curing somebody. Triage is just stopping the bleeding, right? That's what bankruptcy is, right? It's stopping the bleeding, right? Another analogy is it's stopping digging. You're in a hole right now, right? The first thing you got to do is quit doing what you're doing and do something else. And you need to do it in a way that's going to change the circumstances. And I think this is a good pivot right now for me to hand this off to my colleague Margaret. And Margaret Henehan, I think we're going to take a short, it looks like you're mic'd up, ready to go? Excellent. Wonderful. All right, thank you. And we'll be taking some questions as well.
So we have already a lot. All right. Good morning. My name is Margaret Henehan. I am a consumer bankruptcy attorney in Minnesota. So I have an office right by the airport in the Twin Cities, but I serve all of Minnesota. So how the bankruptcy system here works is it's at the state level. So anywhere you live, you file in Minnesota if you're a resident of Minnesota. So I serve the whole state. It's not county by county, which is how we see a lot of litigation. But with bankruptcy, it's the District of Minnesota. So I work anywhere in Minnesota. So what I want to talk to you guys today about is what your bankruptcy options look like, what your rights are in bankruptcy, what you get to protect in bankruptcy, and what debts you can include in a bankruptcy. So first, bankruptcy is divided into two different chapters that I work with. So there's Chapter 7 and there's Chapter 13. These are both your consumer bankruptcies. A lot of people know about Chapter 11. That's for big corporations. That's not what we'll talk about. Chapter 7 and 13 are your everyday people bankruptcies. So Chapter 7 is the bankruptcy where people sometimes will call it the fresh start bankruptcy. It wipes out the debt. It's not a repayment plan to your creditors. A Chapter 7 bankruptcy has to be based off of income, so you need to income qualify in order to do a Chapter 7. So what we do is we look at what your income is to determine if you qualify, and it's based off of your household size. So sometimes we can run into issues of, you live with a boyfriend or a girlfriend, but technically, is that part of your household or not because you're not married, you don't file taxes together. So there's some kind of things that you do want to kind of go through with an attorney to determine what is household size and what that income looks like. But just to give you an example, to qualify for a Chapter 7, if you're one person, not married, no kids, the income guidelines for the year are about $75,000 now as of November 1st. They changed today, so they've got a whole new structure today. So $75,000 for the year is what that income looks like. So it's quite high. A lot of people will qualify for Chapter 7 based off of what the income guidelines are. And in Minnesota, we have higher income guidelines than a lot of other states because it's expensive to live here. Our housing costs are higher than even in Wisconsin. So we're looking at what your income is to determine if you qualify for a Chapter 7. And then we're looking at what your assets are. What do you own? So most important, people don't want to lose house, car, retirement accounts, their business. Those are the most important things we always talk about at a consultation. So if you own your house and it's where you live, you can protect the equity in your house in a Chapter 7. It's up to $500,000 in equity. It's very, very high. Most people we're not seeing with that much equity. But if you've owned your house for a few years and you've been paying down your mortgage, you've got $50,000, $100,000, that's all protected if you do a bankruptcy. You wouldn't lose your house by doing it. So what the court did and what the legislature did was make sure that there's a set of laws to protect the most important things, because no one would do a bankruptcy if they were going to lose everything. No more house, no more car, people wouldn't do this. So there's a guideline of what we can protect. So your house where you live is protected. We don't have protections for just land or cabins or those types of things, but the house where you live is protected. Your car up to a certain value is protected. So the equity in your car, for most people, it qualifies as an asset you get to keep. Certain monies in the bank are protected, your wages from work, your personal belongings, the stuff you have in your house, your retirement accounts, those are protected. So usually when we're doing a Chapter 7, it's rare to see assets that we can't protect. Usually you get to protect all of your stuff. The debt we're talking about including in a bankruptcy is broken down into your unsecured debt and your secured debt. So your unsecured debt is your credit cards, your personal loans, bank loans, medical debts. Those are the things we see the most often when we're talking bankruptcy. People have credit card debt, medical bills, loans they've taken out from the bank. Those are all unsecured debts that get discharged in a bankruptcy. The debts that don't get discharged are child support, student loans for the most part. There's some like government fines or tickets. We can't get rid of those in a bankruptcy. Secured debt, so this is your mortgage or your car loan. Most of the time you want to keep those assets and you just continue to make payments. So just because you're filing bankruptcy doesn't mean you own your car outright or you now don't have a mortgage on your house. You still have to pay those in order to keep those assets. But the big stuff that usually is dragging people down, the reason people come into my office is just overwhelming credit card debt, medical bills, bank loans. Those are what we're usually dealing with. The other thing we see frequently, and we're seeing it more, is vehicles that have been repossessed and now you owe what's called a deficiency balance. So you owe the difference between what they sold the car for and what your loan was. We're seeing repossessions are up a lot this year. And so we're seeing, people no longer have their car, but they still owe $20,000. And there's no way most people can afford to pay that. You don't have the car anymore. So that type of debt can also be included in a bankruptcy just to wipe the slate clean. So Chapter 7 is the bankruptcy we see the most. It's probably 80% of the clients I work with are Chapter 7 bankruptcies. It's the fresh start. It's quick in terms of court. So 3 months from start to finish is the typical timeline for a Chapter 7. So, with any type of court, it can drag on. Bankruptcy court is quite efficient. It moves very quickly. And so for, 3 months, you're in a bankruptcy. And then at that point, you get your discharge order, which is the official end to your case. And you get to start rebuilding your credit at that point. So your credit, we all care about credit. We used to not care that much about credit. Now we all monitor our credit scores and that type of thing. You'll start to see your credit score improve 3 months after filing, and there's ways to improve it and do some active work on your credit report from there. So Chapter 7 is a great tool. Like Mark said, reset, wipe the slate clean. There's a stigma against filing bankruptcy. Everyone knows it, everyone feels it, and it's due in part because we don't talk about finances. Most people aren't talking about what they make or what their debt is with their family and friends. Usually it's very private information. And so you don't hear someone say, oh, I just filed bankruptcy. But a lot of people are, and a lot of people have, and it's just something that isn't going to be top of mind when you want to talk to someone about things. So you'll find that if you ever do start talking about it, you'll find that there's a lot of people in the same spot as you that have maybe gone through it before or are thinking about doing it now. It's all I do. I am a full-time bankruptcy attorney and I have lots of work. So if there wasn't cases out there, I would not have just bankruptcy as my only sole practice. So there's a lot of stigma and I think misinformation around bankruptcy. And a lot of it is in part because banks are really powerful and they don't want you to have some of this information or know how streamlined and straightforward the process is for consumers. There's been a lot of work in Congress over the years to try to put barriers up because those people get paid and incentivized by all sorts of different lenders and banks out there. And so that's sometimes why we see misinformation or the fear that you're going to lose everything if you do this, because there's simply just not good information out there sometimes. The other type of bankruptcy, the Chapter 13 bankruptcy, which I think is about 20% of my practice, this is the bankruptcy for people that don't qualify for Chapter 7 based off of income. So you make more than $75,000 if you're a household of one. And so when you're in that kind of segment of the population, the court thinks there's something to pay your creditors with. There's some money you have left over each month that you could make a payment to a creditor with. And so Chapter 13 is a restructuring. It's a payment plan based off of what you can afford. They're usually set up as 5-year timeline, so it's a 5-year Chapter 13 debt repayment plan, and you pay what you can afford. You don't pay what the creditors want. The creditors get no say in trying to negotiate what they receive in a Chapter 13. They can receive as low as 1 cent on the dollar, and they often do because oftentimes we're prioritizing other types of debt over your credit card, over your medical bills. So a Chapter 13 we use when people make too much money, but they still can't afford what those minimum payments are, or they're just stuck in the debt cycle where they're not making enough to actually break out of minimum payments. They're kind of an interest-only cycle of the debt. A Chapter 13 takes away the interest, takes away the penalties, allows you to just pay principal towards the bills, and actually see the debt end at the end of 5 years. So there's a stop. It's over at the end of 5 years. You're debt-free at that point. Whereas oftentimes, if you're going to try to keep paying your debt yourself, you're going to be in a cycle that sometimes you can look on your credit card statement and it'll show you now how many months or years are left if you're only paying minimums. And you're going to see, I mean, I've seen 50 years on those statements because the debt gets so big and the interest is just taking every dollar you pay. So Chapter 13 can kind of break you out of that debt cycle by paying something you can afford. Usually it's a lot less than what your minimums add up to be because otherwise you wouldn't do it. If we're not saving money in a Chapter 13 plan, no one's going to do it. It's still a bankruptcy at the end of the day, so you want to make sure it's worth your while. There's significant savings by doing it. And then the other thing that I really see with Chapter 13 is it's a tool to get you current on your mortgage and your car note. So a Chapter 13 can take any missed payments you have on a mortgage or a car and spread it out over your 5-year plan and get you current. So from day one of filing Chapter 13, you're marked as current on your mortgage, current on your car note. So it's a tool that stops people from being foreclosed on, having their car repossessed, and giving them a timeline to get current again. So we see this a lot with mortgages. You've fallen behind on your mortgage, you've been out of work, or you've been, only able to pay a certain amount because of all sorts of circumstances. You end up $10,000 behind on your mortgage, $20,000 behind on your mortgage. We take that amount you're behind, we put it in a Chapter 13 plan, and we stretch out the payment so that you've got the opportunity to stay in your house, continue to make your mortgage payment every month, and then you'll have an additional payment you'll pay a bankruptcy trustee that will get divvied out to all your creditors, but prioritizing mortgage, prioritizing car. The other thing a Chapter 13 can do is it can get your tax debt under control. So oftentimes people think tax debt can't be touched in bankruptcy. It can. In a Chapter 13, we can take your tax debt, and it's first priority when we're paying out payments in a trustee Chapter 13 plan. So if you owe $5,000 in IRS debt and $20,000 in credit cards, the IRS debt has to be paid in full before the trustee starts distributing money to anybody else, which is what you want. You want the tax debt taken care of. They're the ones you don't want to play around with. So IRS and Minnesota Revenue get priority over anybody else. So we can also use a Chapter 13 to get you back on track with taxes. And in a Chapter 7, the other type of bankruptcy, if you've got old enough tax debt, that can clear out tax debt too. So there's a couple of rules that always have to be met before it's qualified to just be wiped out, but it's 3 years back on taxes, and then a bunch of different requirements on filing on time and filing yourself and that type of thing. But we oftentimes can get rid of huge tax liabilities that are old, that are still collectible to the IRS, still collectible to Minnesota Revenue, but under bankruptcy are not collectible any longer if you have a bankruptcy discharge. So we can use that tool to talk through tax debt too, because oftentimes we see people have played around with their withholdings because they need a bigger paycheck, because they've got debt they're trying to pay down, and now in turn you've created an IRS bill because you didn't have enough withheld and you went to do your taxes and now you owe $3,000 when you're used to getting a refund. So we can take those types of debts and, depending on the bankruptcy, get them either wiped out or paid down through a payment plan. So with both types of bankruptcies, we've got most assets protected. So the assets that we sometimes don't see protected are going to be your second homes. I don't see a lot of people with these, but sometimes if you've inherited property or land, we can't protect those. If you have a lot of vehicles under your name, sometimes we run into issues protecting all the vehicles. Sometimes we see families put all titles under one person's name instead of each of the adults that drive the vehicles. And so sometimes we've got to be strategic and do some planning about that. But for the most part, most people we see that are coming in, their assets are protected. Do you want me to?
I have a question already.
Okay. Yeah, do we want to both be up here to answer questions?
Yeah, I think both would be
Okay.
But the question is for a business. how you handle the business,
Here we go.
business, small business
In bankruptcy,
in bankruptcy. I mean, they are not, they are LLC accounts.
yeah, that's a good question. Yeah, so if someone owns a business, it's an LLC, we still have to list it as an asset because oftentimes it's just one person that owns it, so they have a 100% interest in the business. So it gets listed as an asset, and then we have to figure out the value. For a lot of people, it's just what they use. It's just their equipment. If they're a painter, it's going to be what they use at work, which we have protections for sometimes of the tools of the trade. If they are owed a lot of money on like an accounts receivable for the business, sometimes that does get tricky. If there's debts the business has though too, we list those debts. So we list the assets of the business, we list the debts, we figure out if there's any equity in the business, and then depending on how much there is, we can either protect it or kind of talk through strategies of what to do to try to lower the value potentially before filing.
Okay, they say the business is losing money.
So if the business, so that's the other question is, do you want to keep operating a business that's losing money? Sometimes I'll tell clients, let's close down the business before filing bankruptcy, because if it's just losing money every month and it's caused the debt, it's causing you to be in debt and you want this fresh start, we don't want you to continue to, after a bankruptcy, still try to put money into a failing business and end up maybe in the same cycle you've been in.
The next question is, what happens if you have your second house is outside of the United States?
Your second
House.
that is still an asset in bankruptcy. So I just ran into this with someone who has a property in the Middle East, and we have to still put it in the bankruptcy schedules and we have to value it. And sometimes the value is going to be higher than you're allowed. And so sometimes we have to do a Chapter 13 bankruptcy because you can't lose assets in a Chapter 13. Everything's fully protected. But technically, if you have property outside the US, you still have to disclose it, we still have to value it, and it is considered an asset.
How far back does the court get information? Do you get 6 months of bank
For
statements?
pay stubs, yeah, so for pay stubs, we do 6 months. For bank statements, the court usually asks for 1 to 3 months.
Sure.
But if there's an inquiry, there's something they want to see, they can go all the way back. They can go back years.
Or they can.
Typically, we're only going to request 1 to 3 months, and that's all they're going to see.
Okay.
Yep.
The next question is, they are already in the Chapter 13, but they cannot pay anymore.
Yeah, so if someone's already in a Chapter 13 and they can't afford their payment, usually I tell people, my clients, stay in touch with me. When you can't afford your payment, you need to set up a call with your attorney and see if there's an opportunity to lower it. Sometimes there isn't. Sometimes the payment is stuck where it is because you're paying tax debt or mortgage arrears. So sometimes we have to talk about if we need to convert the case to a Chapter 7. You can go from one bankruptcy to another. Or can we do a temporary lower payment, so 3 months, and then raise the payment back up because right now you're in a tight spot, but you think you'll make more money in the future. You can change your payment in a Chapter 13, so you can temporarily lower it for a period of time and raise it back up. So I usually say stay in touch with your attorney on what that looks like.
Also, wait a second before we move on though, but isn't it also, because first there was Chapter 7,
Yeah.
and on your note that the bankruptcy code was created to protect consumers, but then there was this sludge added to it, and part of that was the Chapter 13 process, right?
Probably, yeah.
Which made it a little bit more difficult to discharge debts. And part of the thought that was created to kind of hinder a little bit, help creditors, but it certainly hinders consumers, is the fact of the large percentage of 13s that are converted to 7s.
Yeah.
Isn't that around 60% or so?
Not in Minnesota, but maybe nationwide it is. So you can start in one bankruptcy and go to a Chapter 7. Chapter 13s fail more often. 7s really never fail. 7s, you're going to be successful if your attorney most of the time has put you in a 7, it's because it's going to work. Chapter 13, it's up to you to make the payments. And if you can't afford to make the payments, it's sometimes just simply not going to work.
Another question in the 13, my credit score never go up, still low.
In a chapter 13, sometimes it's like frozen. It's not technically frozen, but you'll see it kind of stagnant. What I tell clients, and this is, you've got to know yourself and be careful, but you can have a secured credit card in chapter 13. A lot of people think you can't have any new debt in chapter 13, but you can have a secured credit card. Put your groceries on it every month, pay it in full, and you'll see your credit score go up even though you're in 13.
The next question, they filed to bankruptcy 2 years ago, but they got a bill from doctors.
Yeah, from 2 years ago. That happens a lot with medical creditors that don't know. This is when we refer.
Ta-da!
Yep.
This is where I enter from stage right.
Yep. I send them over to Mark and say, I think you might have a claim.
That's right. So let's talk about that. The one thing we didn't mention, and as far as consumer rights, I want to just mention one word or 2 words. Bankruptcy stay. A bankruptcy stay is the law that comes out of the bankruptcy code. When you file bankruptcy, everyone gets notice, and then they all have to stop contacting you. That's it. They have to stop. If they want to continue to contact you, if they want to continue to foreclose on the house, or if they want to try and pursue some debt because they think it's fraudulent or something like that, fine. The process they have to use is they must file a motion in bankruptcy court called a motion for relief, which is easy enough, but they never do. They never do, right? What do? A motion for relief.
But you need to check with your attorney.
Yep. So ultimately, here's the thing. So once you file, if anyone contacts you after that, right? Yeah, you should talk with your attorney, right? Make sure that they got proper notice. Did it go to the right address? Because if it did, right, they're violating the bankruptcy code. And the bankruptcy code allows for what's called an adversary proceeding. So you personally can bring this proceeding in bankruptcy court. I will do that on your behalf. And again, the bankruptcy code allows for attorney's fees and costs to be paid for by the bad guys, right? They're the ones causing all this to happen. So if you end up getting a letter a year after your bankruptcy has been discharged, or during your bankruptcy, okay, then that's a potential adversary claim. If it's gone to the correct address, well, then they're violating the bankruptcy code, and you can bring a claim. It doesn't affect your bankruptcy at all. We file a claim. It's a sister file that's opened up under the same judge, and they have to answer to the judge and say, why is it that you're just desecrating my precious bankruptcy code? And a lot of times creditors don't want to answer that question. And so because of that, they end up paying damages to you, which is what the bankruptcy code allows. Okay? So these type of contacts are actually, you keep your eye on the ball, because these type of contacts tend to happen a lot and are repeated. Even though you give notice, hey, I filed bankruptcy, give them a call, right? I filed bankruptcy, so don't send me any more letters. And then they send you one next month. And usually that's what happens. I don't represent people that are trying to find some, aha, I've got you moment. I represent individuals that are reasonable and that just do not want to be harassed. And they usually contact me thinking they have to pay me and say, look, just make the contacts stop. I filed bankruptcy. I thought that was going to stop the contacts. What do I have to do, right? And I tell them, hey, this is great. You don't have to do anything. I'll do it all for you, and you don't have to pay anything, right? So now you know, right? Now you're armed with that. When you file bankruptcy, and that's why, see, I used to fight these prior to bankruptcy filings. It's a lot more difficult. There's different laws that apply. Sometimes we win and lose, right? But once bankruptcy has been filed, the bankruptcy code offers such great protection for consumers that then that playing field is a lot better off for consumers. And so if in fact you file bankruptcy and you're getting these continued contacts, I want to hear from you because you've got a claim.
Mark, the question is the same person, but that medical bill come after the bankruptcy.
Okay, so let's talk about pre-petition debt.
Yeah, so you have to make sure that the debt was from prior to filing. So it's literally the day of filing is your wall between what you don't have to pay any longer, your pre-petition debt, And then your post-petition debt, you go to the doctor 1 week after filing bankruptcy, that's your responsibility, that's your bill to pay. So with medical bills, you oftentimes have to look at the date of service to see what they're billing you for.
That's the same with rent. We also run into as well. So sometimes, so prior rent and then current rent. So can they charge you the current rent? Yes, but they can't charge you the $1,200 for rent plus the other $1,200, or even the other $500, or even a late fee on the $500, right? Because that would be charging on pre-petition debt. So, so that's an issue that we look at as well.
The medical bill, the question again, the medical bill, an example, she went to the medical 2 weeks before the bankruptcy.
And then was billed after. So that's pre-petition debt. So they can't collect on that.
That's right.
But she has to probably make sure that the creditor gave notice. So sometimes you have to call your attorney and say, was this listed in my bankruptcy? And if not, they'll have to go and add it. But if they get notice at any time, they can't collect.
And again, how much is for Chapter 7, how much is a single person can file in the
It's about $75,000 for one person. It's about $94,000 for 2 people. 4 people, because I see 4 people a lot, it's like $144,000. So it gets to be pretty high. Yep.
Now, how much is they say they went to the attorney and they say sorry, I guess it's Spanish. Okay, they try to get the intake and they want to charge $500 for the intake. They went to the process, start the process, and they want to charge $8,000, and they only make $55,000 a year.
That would be a lot for a Chapter 7. I usually charge around $2,000 total, and your consultation is free. So
There's no consultation fees for bank.
no consultation. When I do my consultations, I don't charge for them. Some firms do, though $500 sounds like a lot for a consultation fee, but I don't charge for consultations.
I do not charge for consultations either. So if you have a question.
That was the question here.
Yeah.
Do they charge for consultation?
Nope, no fee.
We
Nope.
want to talk to you.
Yep.
Then actually the service for attorneys is free in this point, but they need to pay you in the front before to file bankruptcy. But it's between $2,000 to $4,000, would we say?
I would, 4,000 would be very, very rare. It's usually really close to 2,000 for most people. If people have businesses and it's more complicated, that's when I see 3,000 or 4,000. But for most people, it's very close to 2,000. Yep.
$2,000 is all my family, friends, everybody, Latinos, es $2,000 hasta $4,000 máximo. Los 5,000, 8,000 es en realidad una cantidad muy excesiva, and talking about that between 5,000 and 8,000. We really lately we are seeing.
Really?
Wow.
That's crazy.
That's why we are doing this.
Yes, that's
crazy.
very expensive.
You know?
Yeah, that would be very expensive.
And it's $500.
Yeah.
Yeah, for the
It's
consultation. No.
$75,000. No, I'm sorry, $75 to $500 consultation. Then technically consultation is free.
Yep, we do them free.
What they need to bring to the consultation?
So usually I tell people an understanding of your debt and what your income is. So you don't necessarily need to bring physical documents. I do a lot of consultations over phone or over Zoom. But if you know how much you make, you know what your debt load is, we'll talk through what you own, your house, your car. That's really all you need to know. If someone wants to gather documents and start to, put things together for a consultation, I'll ask for pay stubs. So a couple of most recent pay stubs, your taxes you filed this year, any credit reports or bills, any invoices, gather them all up and bring them in, and we can start sorting through stuff.
Now this question comes from the accounting. We also have one accounting here in the class. What a business companies they needed. I mean,
What does a business need?
Mm.
So if
I'm sorry, self-employed.
Oh, if they're self-employed, I want to see either their bank statements that show how much they bring in, 6 months of bank statements, Or if they do profit and loss statements, they do QuickBooks or some sort of online accounting, I want to see their profit and loss statement for the year, and I want to see a balance sheet. So if they do those kind of formal accountings, I want those. If they don't and they're just paying themselves and I can see the income coming in on bank statements, I'll take those.
Okay. Now, the next question is, okay, there is so many right now.
Let me jump in here, just so everyone does know though, right? You're thinking potentially about filing bankruptcy, so right now is the time to start organizing everything. Organizing all the different documents that Margaret's mentioned, right? Whenever you have contact with any of these debt collectors or with any of the creditors, you want to notate that. When that happened, who you talked to, who called, what was the phone number. A lot of times if it's an email, that's easy, right? I mean, that's already done. But ultimately you want to do that because ultimately if you end up having a case, you want to have all those contacts. Now, for the most part, prior to bankruptcy, it's all informational stuff. But after the bankruptcy filing, it's all communication stuff. Who's sending you letters? Who's sending you texts? Who's calling you? And as soon as it happens, the best way to do it is to send an email off to your attorney or me, and ultimately that way that there's a record of it, right? Of when they got notice or how they got notice. Again, that's what's going to help your potential case. The more paperwork and all of that organization you have, that's going to get you to the bankruptcy table and into the bankruptcy court. But ultimately, what's going to really stop all that harassment as well is just being organized throughout the process.
They're garnished my wages. Can I stop?
Bankruptcy stops garnishment. So the filing of a bankruptcy would stop the garnished wages. And depending on their case, what they have for assets, we can sometimes get the money back that they've taken in the last 3 months. So usually I want to see people file bankruptcy shortly after they start getting garnished, because one, I want it to stop because they're going to just start falling behind on rent or mortgage, and then we can see if we can get the money back.
You got to tell them what it's called.
Yeah.
The clawback.
The clawback.
The clawback.
We
It
can
sounds
claw
great
back.
even. Yeah.
Yep.
So we can claw that money back for you.
This question is for Mark. The question is, they call and they told them they will serve in court. That is possible?
Okay, so here's the thing.
Lately, I think they try to say is lately a lot of Spanish speaking consumers, they get this call, say, hey, you owe me the money, I will set up paper tomorrow in your house, you pay me right now.
Yeah.
Oh.
So, okay. Let's just take a step back to the harassment. First off, of English as a second language, or third or fourth language, I find that those consumers are most harassed, right? Because I think that native speaking English folk think somehow that intelligence is somehow related with your language skills in English. And so what ends up happening is a lot of shaming, a lot of harassment, and a lot of abuse. And that's just in general with non-native English-speaking consumers in the last 23 years that I've represented. So that's one of the things you're going to want to consider when you're talking with anyone else, is that you may be hearing things that other people would not hear. And sometimes those threats, and that can be very fearful, of course, because you don't know if it's true or not true. But some of the common threats that I see, which are illegal and unlawful, is there's a what's called the Fair Debt Collection Practices Act. That's the consumer statutes that protect you against debt collectors. And under 15 USC 1692 E5, they are not allowed to make threats to do which they unlawfully cannot do, or that they do not intend to do. So, I'm going to sue you if you don't do this by tomorrow. Well, tomorrow comes and goes, and you haven't been sued. Well, that's a false threat. I will sue them for that. Here's another one. You need to pay, this is your last settlement amount. You need to pay this by Friday. You got to pay $1,000. But then on Monday, they call you up and say, you know what, we'll take $750. Well, guess what? They can be sued on that false threat. Even though they're reducing that amount, they told you you're going to be sued and you have to pay this amount, and then they changed it, right? That's what I mean. So debt collectors, if you're talking to a debt collector, they are under a different standard than creditors. What's a debt collector? A debt collector is any third party collecting on a debt. It could be a lawyer, It could be a debt collector, Reliance Recoveries, somebody you don't recognize, not your credit card company, not the bank, not the credit union, right? Anybody else collecting on that. They can't lie to you. They can't threaten you. They cannot shame you, right? Debt collection should entail, I'm calling you regarding this debt. Can you pay that debt? I'm going to call you next week. Would that be appropriate? Can you pay this debt next month? Okay, I'll update my notes. That's debt collection. When it deviates from that, can you call your mom? What kind of a mother are you? Is that your dog in the background? It'd be terrible if you lost your dog. I've had all those cases, right? So that's what I mean. All of that is harassment. You don't have to put up with any of that stuff, okay? And particularly, again, sometimes it's splitting hairs. Is this a case? Is it not a case? I'll certainly talk with anyone about any of those facts. But once you file bankruptcy, right, then, boom, all of those contacts have to stop. And so that's what's very important, because then if you get a letter, whether or not it's harassing or not, you can't even get that contact, right? It's black and white. It's a strict liability statute. We don't have to prove intent necessarily with debt collectors, okay? With bankruptcy we do, but I'm not going to confuse you with that issue. Just know that collection contacts are very important, and the biggest violation are false threats.
I was just going to add to this quick. We're seeing a lot of scams. So oftentimes you don't know who's on the other side, and it could be a scam. It could be someone you don't owe money to, but they're going to try to threaten you. And we see even in emails, we can send the sheriff to arrest you if you don't pay this amount of money. So I always want people to know you can't be arrested. No one is going to come and arrest you because you have an unpaid bill. That can't happen. But we get lots of people who think it can and are very afraid and want to send money to we don't know who, and it's just a scam at the end of the day.
That's right.
Another question, I owe money to my family members. Can I discharge in bankruptcy?
Yes. So family, friends, anyone like that can be included in a bankruptcy, and they cannot collect against you in the future. Now, sometimes I say, do you want to list your mom or dad, or do you want to just work something out in private? Because you always can voluntarily pay them. So if you didn't want to include them, you could work it out. But technically, you include all your creditors, and that can be family. Yeah.
The next question is, the bankruptcy can affect my FAFSA?
Right. Your FAFSA is not based off of credit score or bankruptcy status. So you're still eligible for student loans. You can apply for them in the future. You can be a student and file bankruptcy and it not affect distributions of student loans. That is true.
I filed bankruptcy after 7 years, and I already discharged, but still reporting in my credit.
Yep.
10 years.
10 years.
10 years. One thing we talked about a little bit earlier too, about the chapter 13. Let's talk just a little bit about credit reporting, right? So sometimes that's what forces people into bankruptcy, right? Because you're not able to pay on a few debts, so what? Well, how does that turn up? It turns up on your credit report, right? There's a 30-day late, then there's a 60, then there's a 90, then there's a 120 late, 120, 120, 120, 120, 120. Meanwhile, your credit score is going down. You're going from 800 to 750 to 720 to 620. You go into the credit union, you say, hey, I want to get a loan. They say, okay, great. Oh, you know what? You are 5 credit points too low for us to give you a loan. I tell you what, though, you can get a loan online, but then you're going to pay 27% for the interest rate. And all these crazy things are happening. Why? Because of the credit reporting. So, something to consider. When you file bankruptcy, and so this is what I tell folks too, and Margaret had brought this up, a lot of times with a mortgage they'll tell you, if you make the minimum payment, you're going to pay this for this lifetime and half of your next one, right? And you're like, oh my God. It's interesting to be able to look at your own credit, your payment plans. I talk with people all the time, they're like, okay, I owe $2,000, I'm making $50 a month payments. I'm like, are you kidding me? You're not even making the interest payment. You'll never pay that off, right? That's never going to help you. So the difference for them is this. They feel good about making that payment, but that $50 is more important to them than it is to Discover Card, right? And it's not purposeful. It's not changing anything. In fact, every single day they pay $50 and they flush it down a toilet, and ultimately their credit score goes lower, right? And what I tell them is if you file bankruptcy, The difference is that debt is gone. And then the next day, your credit score is going to start getting better because you don't have negative defaulted debt. You'll just have no debt, right? And in fact, you can do the opposite. You can have a secured credit card with your bank and all of a sudden you're building credit. And yeah, for a while it's not that great, but a year, 2 years from the bankruptcy, now you're on the upswing with your credit score. You don't have any of that defaulted debt. You don't have any of those debt collectors that are coming after you, right? So it solves all those problems. But again, focusing on the credit portion of it, a bankruptcy filing really kind of cleaves off all of that bad credit. Keep in mind that a Chapter 13 is not an immediate fix. They don't have to report on your credit report until you're done paying it off. Once you're done paying it off, then they got to retrofit your entire your credit reports, right? And they can't report the lates during the bankruptcy and all that stuff. But
even the balance, if they are paying.
Ultimately, at the end, no. But during, they can. The consumer doesn't get the bang for the buck until the last payment is made. Okay? And when that happens, sometimes people have some problems then. I've had a couple cases where all of a sudden somebody's made payments for 5 years, and then, the very first month they go, you're 30 days late. They go, well, how can I be 30 days late? Some accounting error that happens at credit unions and banks. It happens, right? And it's not on you. And you have resources now to be able to kind of explore those and to fight those if you need to.
Yeah, here I have the best question. Oh my God, this is actually I was thinking this, but Migdalia, she asked, if you follow the bankruptcy, it's affecting my ability to become a citizen. She's a resident permanent right now. In 4 years, she is able to apply for the citizenship. That is going to affect somewhere, somehow?
So my understanding, and I'm not an immigration attorney, but I've spoken with immigration attorneys on this, and this was, the administration is a little different right now, but previously the advice always was if there was a bankruptcy on your record and you were applying for citizenship, it would not affect your case. Now, they would say if you had all of these other things that potentially were red flags on a citizenship application and a bankruptcy, maybe that could give weight to a denial. But I've never heard from an immigration attorney that just having a bankruptcy would affect your ability to be a U.S. citizen. I've had lots of clients that are on that pathway and have become citizens, and I've never had the feedback that someone couldn't become a citizen because of it.
I think
Yes.
if I have IT number, can I qualify for the bankruptcy?
No, you have to have a social security number.
Okay.
Yep. So you have to have a valid social security number with legal status because bankruptcy is federal court and that information can be shared amongst other federal agencies. So we don't want to file anyone that doesn't have a valid social security number and isn't here legally.
Then these other companies, they are offering bankruptcy for people with IT, then they are not doing
I would not do that filing, and most attorneys you talk to would not either. You can hire someone who is a preparer, a bankruptcy preparer, and they're not an attorney. I wouldn't trust someone to do it under, especially with the administration right now, because I have heard cases in other states where people who are undocumented and have filed bankruptcy have had ICE called, and so I don't want to take that risk for anybody. I've said no to people that have come to file bankruptcy with me and given them advice on how to keep creditors off their back for now. Talk to Mark, because we don't want to risk, that would be a huge risk to take.
And the next question is, we have a lot of questions, but this question is, they got served, she called the attorney's office to make a payments plan, but they asking for the full balance and she's not able to pay. And she feels intimidated. What she can do?
It depends on how much she owes, and it depends on how many other debts she has. Sometimes this is why people file bankruptcy, is because that judgment is too big and they can't afford it. And sometimes we see creditors that will not work. They won't do a payment plan. So sometimes it does force people into bankruptcy. Sometimes you could try to hire an attorney to negotiate. So I've been hired not to file bankruptcy, but just to call the creditor and negotiate a payment plan, because sometimes they'll talk to an attorney and they won't really give a deal out to someone who's not represented. So sometimes I do a lot of that work in terms of just setting up payment plans because the client can't get anywhere.
And this is this is really kind of my alley, which I've done for 2 decades. And ultimately, one of the reasons I'm here today, because I used to just be on the one side of just trying to negotiate that debt so that people wouldn't have to necessarily file bankruptcy. And the issue really comes down to, so even for this individual person, if I was talking to her on the phone, the first thing I'd ask her is it your only debt? Mm-hmm. Because if it's not, and you've got more debt, right? I've already talked about that scenario. Well, then why would you pay on this one as opposed to paying $2,000 and getting rid of all of them, right? But maybe it is the only debt. Or for any other reason, bankruptcy is not an option. They have a second house, we'll say, or what have you. Okay, fine. Well, then ultimately, then you're going to have to consider how to pay that debt. And if it's in litigation, then one of the things you might want to do is to serve an answer. Now, what does that do? That stops the clock, okay? As if you have a defense to the claim. It's not exceptionally difficult to do, but nonetheless, that's an option for you. And a lot of times, just as Margaret has said, if you have an attorney, sometimes, when a letter comes on an attorney's letterhead, I get through the front door, right? Whereas I get to the attorney, whereas when consumers just call, they get the debt collector, right? But they don't want me talking to debt collectors because I sue them, right? So they get me to the attorney right away. And that's what Margaret is saying. Well, a lot of times that happens as well. If you file the answer or serve an answer that just denies the claim, and ultimately then that stops the clock and they take you seriously, and then they try and negotiate the debt. The other option, of course, is if it's conciliation court, which is also called small claims court. Always show up. Always show up. Because the judges often say, have you had an opportunity, the parties, to talk and try and resolve this? And then they kick you in the other room to try and do that. And sometimes that forces their hand too. So that's just kind of another potential off-ramp to not having a judgment against you. Now, keep in mind, if you do nothing, you don't call them back, you don't respond, you don't serve them an answer, and you don't show up at court, we know what's going to happen. You're going to get a default judgment, and ultimately, nobody sits around with a default judgment. What do they do with that? They're going to try and garnish you. They're going to try and levy your bank account. You're going to get additional debt collection. So that's kind of what's going on with that. But again, that's some of the considerations.
And another question is also, it's a good question because it's a lot of, this idea about removing the collection account or charge off from your credit report, you don't owe nothing, you still owe the money. And this is the question they hired a company in Florida to fix their credit and they removed the account, but now they are suing them. And I all the time tell people, you still owe the money.
You still owe.
Obligations.
Yeah.
At this point, what they can do.
Yeah, you still owe the money whether it shows up on your credit or not. So depending on kind of your overall how much debt you owe might determine bankruptcy or just trying to settle with that one. So in Minnesota, there's a new law that medical bills can't collect on credit anymore. They can't report on credit. Doesn't mean you don't owe the debt, just means that they're not able to put the debt on a credit report. So I always tell people creditors have to pay money to report on credit, and some creditors don't want to pay the money, and so therefore they're not going to be on the credit. They still can collect, they still are a valid debt.
Well, and speaking of scams, I'm just going to say that Florida company is a scam, okay? So if you don't, first off, don't hire people to fix your credit, just don't, right? Except for this person. Right. Exactly, right? Because that's a big
Minnesota-based is usually good. Right. There's a lot of them in California and Florida, and they are terrible.
Terrible. And they all have arbitration clauses, and they all have jurisdictional clauses. So you either have to go to Texas or Florida or California for a reason, right? And you're never going to do that. So what ends up happening? You sign a contract with them, you send them money, and then you get sued. And then they go, sorry, we can't help you. Right? And then what are you going to do with that, right? The only possible people you can sue is maybe that company, but even that's probably not a good idea because you're just going to waste time and energy and money doing that. So again, the best thing to do is try to stay away from those type of companies. Go to someone like Jessica that can assist you and guide you in a way that where they're certified and they have your best interests at heart.
The next question, they hired this debt consolidation company also.
Yeah.
And they offered them to settle their accounts, but lately nothing happened. They are paying for 2 years.
Yeah.
$350 a month, and now they are getting served. Can I sue that company?
So you should demand that money back. Again, they're not doing anything for you. It's just a bank account that you're not getting interest on. That's your money, right? So ultimately, yeah, what you need to do is to demand all that money back, get as much as you can, and then handle your own finances. Again, you need to go through somebody who's certified, who's got your best interests, and if just sending off money like that is going to be very difficult. You should have been told what's going to happen and when it's going to happen. And the questions you want to ask are, what if I get sued? When will this be done? How much will this cost me? Not today, but ultimately, right? If they can't answer those 3 questions, then no scam will. Right? Because they want you to continually pay. They're not going to give you a deadline. And ultimately, they won't give you results because they don't have any, right? So those are the 3 main questions that you should be asking whenever you're dealing with someone. If you're already on that path and you've already given people a year's worth of money, demand the money back. It's your money. There's no reason they shouldn't just cut you a check and send it to you. But guess what? You're going to have problems getting that money back. And that shows you, right, that something's going on. But ultimately, that's the first thing you should do. Do it in writing. Do it by certified mail. It's worth a few dollars to go to the post office and send it off. And the reason is because you want to have evidence that you've sent a demand for that money and the money is returned. Because if they don't return that money, potentially you have a case against them. Not necessarily a great case because they may not be that collectible, but it is a case where you won't have to pay attorney's fees. So at least it won't cost you anything for an attorney to review that and possibly prosecute that case for you. Okay?
And this question is for Mark. Okay, you say about compensation. What are you talking about? What kind of compensation a consumer can get?
That's a really good question. I didn't talk about the type of damages, right? So what type of compensation can you get? Well, it depends on the law that you bring. So we're talking about bankruptcy. Let's say that you file bankruptcy and somebody continues to contact you, right? And they went to a good notice, right? They got proper notice, they went to their address, and maybe you call them on the phone and said, hey, knock it off, and they sent you another letter, right? Well, what is that worth to you, right? Ultimately, these cases 10, 20 years ago used to max out at like $500 for the consumer. And sometimes that's still the case. It's not a huge amount, but a lot of times nowadays that turns into a few $1,000s, sometimes 4 or 5. And that's just for a couple of contacts. And again, that more than doubles, triples potentially what you're paying for the bankruptcy, right? So it is that important. What type of damages are they? Well, according to the code, you can get actual damages. So let's say they take money out of your bank account, okay? That's not very common. You can get garden variety emotional distress damages. And who enjoys dealing with debt collectors or being contacted or having to talk to a second attorney after you've already hired an attorney, right? And so obviously, those type of damages get paid out as well. And then again, attorney's fees and costs get paid. And so the harassment gets stopped. There is some amount, nebulous amount, depending on the facts of the case, that goes to the consumer, and the attorney's fees and costs are paid for as well. So that's how it works with the bankruptcy code. Outside of the bankruptcy code, there's other consumer statutes. I won't go through all of them. There's really only a small handful that are helpful. But they also have attorney fee provisions. They also allow for actual damages if money has been taken from you or if you're due money. And There's also the garden variety emotional distress damages. Now I say garden variety emotional distress damages. What I mean by that is, right, the anxiety and frustration of like having to deal with a debt collector on the phone, okay? And what that makes you feel like and how you can explain that. You know, how it affects your relationship with your spouse or significant other, how it affects your sleeping, how that affects your work environment, how that affects your friendships, right, and your depression. Right? Those type of things can be compensated for. Now, and we need to have some sort of evidence, but we can have evidence of those things with testimony from you, with testimony from your spouse, from your employer, from your confidant, from your friend. Those type of things can be, we can get evidence in those forms. We do not need therapist notes. We don't need psychologist notes. We don't need pharmaceutical receipts. You know, we don't need those things. In Minnesota, you do need those things. Outside of these consumer statutes, in order to plead emotional distress, you need something like that. You need a doctor to testify. You need receipts. You need therapist notes. But not in these consumer cases. In these consumer cases, and again, we're not talking millions of dollars, that's not it, but we are talking there is an amount that's arguable. And that adds value to these claims, and that's what I'm talking about as far as the damages.
This question is, she moved from Nevada to Minnesota, and she started getting a garnish from Nevada company. She never went to the court, she never received any paper until now when they start garnish her wages, what they can do.
Oh, go ahead.
Go ahead.
Oh, I was going to say, it could be that they couldn't find her to serve the papers in Nevada. So depending on what the state law is, sometimes they can just post it publicly, like in a newspaper. She's never going to read that newspaper, so she's not going to know about it until maybe her company does receive the garnishment. Doesn't change that it's valid. It is valid most likely. Usually by the time we get to garnishment, there's no going back to appeal it, to say, no, I never knew about it. You're kind of just out of luck because of maybe circumstances or they had a bad address on file. It probably is, and once it starts to be garnished, you really can't negotiate with the creditor because they know they can take 25% of your wages. So unless you're gonna volunteer more every month, they're not going to say, we'll work a deal with you most likely.
And now the question again is, this question is again because again, in my community, they are charging these fees for bankruptcy and they're charging this kind of crazy fees. And now, again, it's no fee, and also they want your contact. We are also sending everybody link to each contact for Mark and Margaret, again, because they want to hear from you, not from me.
Sure.
How much is exactly the average you can charge for bankruptcy is the consultation fees?
Yeah, so consultation would be free. $2,000 is very typical for everything. So a Chapter 7 court filing fee is $338. That will never change no matter who you go see. Always $338 that goes to the court. And then there's 2 credit counseling courses everyone has to do when they file bankruptcy. You do one before and you do one after. I pay for those credit counseling courses, so that's how I get my fee to $2,000, around $2,000. Those credit counseling courses are about $100 total, $338 for the court, and then that leaves me between $1,500 and $1,600 in attorney fees. So that's the breakdown of everything. So sometimes you can find people that you'll have to pay on top of the normal fee for your credit counseling, for your credit reports. I don't charge for credit reports. I run all 3 credit reports, and then I pay for the 2 credit counseling courses you have to complete.
Wow,
So that's how we get to the full fee.
We need to talk about. For Mark, the same question.
Mine is easier. I don't charge anyone anything. I don't eat what I hunt. I eat what I kill. So if I think you have a case, then I will sign you up. I will file that case. And if I win that case on your behalf, I get paid. And if I don't get paid. You don't owe me, nobody owes me, and any costs I have, I eat. So ultimately, for me, it's much more of a front end, let's talk about it. I'm not as able to help as many people as I would like because ultimately I have to keep the lights on and I have to make sure that I've got a good claim. But the fact is, that happens a lot. And it's nice. So my clients like that, and I like that as well. Is I don't have clients, I don't hold their money, I don't, what I do is I am a tool, you open the toolbox and pull me out, and then I go get us paid. Or I at least try to. And if that doesn't happen, you're no worse off than when you hired me.
Perfect, Mark. Well, thank you, Mark and Margaret. I mean, we have
Welcome.
more question, but I know we can probably leave for the next time. And thank you so much. We have a lot of people jump into class, and I know they could not make it here for many reasons, but we are glad they will get your contact. A lot of people they asking for your contact already.
Good.
And thank you so much.
Yeah, you're
Wonderful.
welcome.
Thank you.
Yes.
We appreciate
Thank
the
you.
opportunity.
Yes.
Thank you.
Sounds good.
Thank you.
Yeah.